Good morning. Welcome to day 3 of the Federalist Society National Lawyers Convention. My name is Jeff Wood. I'm a partner in the Washington, D.C. office of Baker Botts. I serve as the chair of the Federalist Society's Environmental Law and Property Rights Practice Group. Our executive committee is comprised of environmental and property rights lawyers from around the country. We hold events monthly, sometimes several each month, and produce publications on a wide range of environmental law and property rights topics at the intersection of constitutional governance and property rights and environmental law. Our main mission is to host robust debates between leading scholars and practitioners from diverse viewpoints, and today is certainly no exception. Our executive committee is honored to have planned this morning's panel discussion entitled Environmental Law After West Virginia v. EPA, Can the Biden Administration's Whole-of-Government Approaches Survive Judicial Review? A panel of distinguished scholars and practitioners will consider whether the Biden administration's broad-based environmental agenda can survive judicial review in light of this important, pivotal new Supreme Court decision. I'd like to take a moment to recognize 2 particular members of our executive committee who helped put this event together, Corinne Snow and Stephanie Maloney. Thank you very much for your help with this. One quick housekeeping matter, CLE credit. So for those of you who are pursuing CLE, we remind you that to get credit, you need to sign in and out each day, once per day. Signing in and signing out can be done via scanning the CLE QR code. If you are pursuing CLE and you have not checked in, please be sure to scan the QR codes that you should have been handed at registration, or feel free to grab a QR code from one of our volunteers standing in the aisles who are ready to help. If you have already checked in via the QR code, however, there's no need to recheck in, apparently. So please be mindful of that if you want credit. One other programming note, one of our 4 panelists withdrew yesterday, so we have adjusted the times allotted for our speaker comments, and we may have a bit more time for audience Q&A than previously planned, so please get those questions ready. Now it is my privilege to introduce our moderator for today's panel, Judge Lawrence Van Dyke of the United States Court of Appeals for the Ninth Circuit. Judge Van Dyke is no stranger to environmental law. Prior to his confirmation to the federal bench, he served as a Deputy Assistant Attorney General in the Environment and Natural Resources Division of the U.S. Department of Justice. He's also the former Solicitor General of 2 western states, Nevada and Montana, and previously worked as an attorney at Gibson Dunn. Judge Van Dyke received his law degree, magna cum laude, from Harvard Law School, where he was an editor of the Harvard Law Review. He lives in Reno with his wife and 3 children, and is an exceptional lawyer and a good friend. So, Judge, thank you for your service to our nation and for moderating today's discussion by our talented speakers. Thank you.
Well, thank you very much. This is quite an honor to get to moderate on such an important topic and with such a great panel. And it's nice to have such a big audience. I think, maybe a quarter of them are my clerks over here, but, that counts. But no, it's really nice to have everybody here. And then, as we said, I think we'll probably have a little more time for questions, which is great. And we look forward to getting the audience for questions. But before we start, let me go ahead and just give a brief introduction to the panelists, who I expect probably don't need any introduction to this audience, but that's what my job is to do anyway, since that's really all I do up here. So I'm gonna introduce them in the order that they're going to present, and the way it's going to work is you're familiar with this. They'll give the opening statements, and then we'll have another pass through so they can respond to any thoughts they had after hearing the other panelists' opening statements. And the order we're going to go in is Lindsay's going to start us off, and then Derek, and then Sean. And Lindsay is the Solicitor General of West Virginia, where she manages the appellate and high-stakes litigation for that state, including the case that we're going to be discussing a lot in this panel, the West Virginia versus EPA case. And she clerked for Judge Thomas Griffith on the D.C. Circuit. And before serving in that role, she worked in appellate and administrative law with Gibson Dunn, that's just across the street right over here. And I know all that because we have a very similar resume, Lindsay. And then Derek is going to go next, and Derek is the Executive Vice President at the Heritage Foundation, and where he oversees policy and advocacy departments for that organization. Before Heritage, Derek was the Senior Vice President of the American Fuel and Petrochemical Manufacturers, and he's held roles in all three branches of government. He served 4 senators and 1 representative in a variety of capacities, and he was a staff secretary to Vice President Richard Cheney. And he also clerked for Judge Sidney Fitzwater in the Northern District of Texas, and I practiced law for 5 years, not too far from there in Dallas, where Judge Fitzwater was and very much admired as a very impressive district court judge. And last but not least, we're going to have Mr. Sean Donahue is going to present, and he's a partner at Donahue and Goldberg. His practice specializes in appellate litigation, and that includes environmental cases in state and federal courts, such as West Virginia versus EPA. He clerked for then Judge Ruth Bader Ginsburg on the DC Circuit, and then also Justice John Paul Stevens on the Supreme Court. And he also worked in the Environment and Natural Resources Division of the Department of Justice in the Appellate Division, where he would oversee probably the types of cases when my section that I oversaw would lose, but we didn't overlap. So, but that was basically what appellate did. I think Jeff would say the same thing. So with no further ado, we'll go ahead and kick off and start with Lindsay. I think Lindsay's going to sort of set the table, among other things, set the table and talk a little bit about the West Virginia versus EPA case for those of you that aren't familiar with it.
All right. Well, thanks so much. It's really a pleasure to get to be here this morning with you all and to get to be on this panel. I'm looking forward to the discussion. So as the judge noted, part of what I'm going to do is set the stage with some of what happened in the case, and I understand that many of you are familiar with that. I know there was a panel on it yesterday, so I will try to move fairly quickly through the highlights on that point. And then when we get to the point of talking through what the court held in the decision, then I want to talk a little bit about some observations from the state side and some thoughts about this topic for the panel of what are the implications for the decision when it comes to other agency actions and this whole of government approach. Before I get started, I do want to say it's a real privilege to have had the opportunity to work so closely with the coalition involved in this case. It was a real honor to get to argue in the court on behalf of West Virginia and our state coalition. But I want to recognize so many other people who were part of this case. This is an effort where we had a large state coalition, but also a private coalition that many of you have been involved in different areas. So we really appreciate that commitment along the years. Also want to give thanks to my office and my team. So I don't think there's any current members of our SG group right here, but we have a couple of former colleagues. Dave Tryon is here, and then Tom Lampman, I don't know if he's in the room, who've got on to bigger and better things in the past 6 months or so. And then, of course, I would like to thank General Morrissey for his deep commitment to this, the Attorney General of West Virginia. I became involved in this case in 2017, but he was involved and really in the weeds from the beginning back in 2013. As anyone who knows General Morrissey will say, he is has a deep history as a regulatory lawyer and is very interested and passionate about checking agency overreach. And this is an area where he took a lot of ownership early on and helped to develop some of the arguments for years in the making, worked really closely to build coalitions, and kept this process moving forward and put the office's resources in it and then stayed the course even when there was some opposition and pushback along the way. So it's a real privilege to be able to work for someone who has that commitment to the rule of law and the issues that we're focused on and we're all interested in discussing and debating in this context. So with that said, I'll talk a little bit about the background of the case. Like I said, I will try to keep this part as brief and painless as I can. But of course, we're dealing with a complex environmental statute and a very interesting procedural history. So no real promises on that, I guess. So when it comes to the statute itself, this case turns on a provision of the Clean Air Act that deals with EPA's and the state's cooperative authority to regulate emission reductions from stationary sources. And the case focused on power plants, and that's where most of the focus is here. But the statute defines stationary source very broadly as really any building or facility. So we're in a stationary source now. Presumably you all live in one. So it can have a very broad scope in terms of EPA's authority here. And the particular statutory language that the Supreme Court was focused on is the part of Section 111D of the Clean Air Act that says EPA can identify the best system of emission reduction. And so much of what tied up courts for the better part of a decade was what does this best system language mean? So that's really what we're dealing with. Before 2013, this provision of the Act had been used only a handful of times, and EPA had generally limited it to this idea of a system of emission reduction as something that a particular source could do to reduce its own emissions. Now, I know there's a little bit of disagreement on that. I think Sean has a different view on one of the rules, but by and large, the few times the agency had used it, it had really been limited to the source-specific sense. Well, that all changed with the introduction of the Clean Power Plan under the Obama administration. And I think something that is probably not controversial is it was announced self-consciously to be an aggressive transformation of the power sector. So that was the intention of this rule from the beginning. And what was different from the previous iterations of rulemaking under the statute is that it's no longer looked at what a particular source could do, what a particular power plant could do through scrubbers or other technology to reduce its emissions, but it really looked broader at the entire electricity grids and said, okay, the best system can include generation shifting, from shifting sources of electricity generation from fossil fuel-fired plants over to renewables and natural gas. And so this broader systems-based approach was a huge shift in the way that the agency was approaching its authority. So unsurprisingly, a lot of people were very interested in that. There were dozens of states and dozens of private parties who filed litigation in the DC Circuit immediately. That court did not stay the rule from going into effect, but as many of you know, the Supreme Court did. And at that time, even though of course in recent years the activity on the so-called shadow docket has become much more common, at that point it was the first time that the Supreme Court had issued a stay to keep a rule from going into effect pending litigation. So the DC Circuit moved forward with the case. It heard it en banc in the first instance, but then before it could issue a decision, there was a change of administration. So when President Trump came in, as you can imagine, that his thoughts on that were about as different from the previous administration as you could get. He directed EPA to revisit the rule. That's around when I got involved in this case in 2017, when EPA under the Trump administration was revisiting, ultimately repealing, and then replacing the Clean Power Plan rule. One of the things that I think is important to note about the legal basis for this repeal is that EPA said, look, there's only one way that we can read the statute. The statute says we have to look at a best system of emission reduction that's limited to what a source can do. And that's important, as all of you know, in an agency deference context. What the agency did not do is say, we think this statute is confusing, and because it's ambiguous, this is the interpretation we're picking and the court should defer to it. They said, actually, we only have one option. You cannot read the statute another way. And that really set up the case for the way that the Supreme Court was looking at it, and why this isn't just a case where the court said it's a permissible interpretation, we're going to defer, but really had to take that question head on. So then, of course, we have lawsuit 2. And so all of the same people are still interested, file lawsuits. Everybody flips to the other side of the V, basically. Everything starts again in the DC Circuit. At that point, we had a 9.5-hour virtual argument that I hope never to have to do again. I think that's something maybe Sean and I can agree on as well. What was different this time is we did get a decision from the DC Circuit the day before President Biden's inauguration. And that decision came down. It was 2-1, and it said EPA had reversed its decision on the Clean Power Plan based on a faulty view of the statute. That idea that it was limited as a statutory matter to things that a source could do, that wasn't actually true, and the court told EPA, go back, try again, and consider the full range of authority available. It said, EPA, you've tied your own hands here. Don't do that. Untie your hands. Go back and consider everything. So then we had a decision that could go up to the Supreme Court. And so West Virginia's coalition, North Dakota, and a couple of private parties as well filed petitions that the court ultimately granted. So that takes us up to the decision itself. I want to talk briefly about some of the standing and mootness issues. I may be the only one who's really interested in those technical things, but I think it has some, and I won't go into all the details of the reasoning, but I think it has some implication for this idea of how we can expect courts and the Supreme Court in particular to be policing agency action going forward. And then in the rest of my time, of course, I'll talk about the major questions piece. So the standing and mootness argument came up from this idea that the Clean Power Plan rule had never gone into effect because the Supreme Court had stayed it, and the Biden administration announced that it, again, was going to be revisiting the rule of the prior administration. So there wasn't a rule currently in effect. And the federal government and the Supreme Court argued that it's a standing issue, and the majority in the decision dispensed of that pretty quickly and said, look, actually there is standing here because the effect of the decision below is to bring back to life the Clean Power Plan, and any stay of that really goes to a separate mootness doctrine, which is an extremely high bar in the party who's trying to defeat something as moot. So essentially nothing to see here on the black letter law. One of the things I think is significant there is, though the dissent obviously disagrees with that, there's not a whole section of the dissent that explains why that's wrong. So there's not really a lot of meaningful disagreement when it comes to the technical standing and mootness argument. I think where that fight really came down to is more of a prudential question of whether the court should have taken this case at all, given that we all knew that new rulemaking was coming. And there, I think you can only speculate, of course, but I think there's a couple of things that probably inform the court's analysis. We certainly argued in our briefing at the cert stage that when you have changed administrations and with how long rulemaking and litigation takes, sometimes not having an answer becomes the answer, especially when you're dealing with industries that plan decades in advance. Something else that was probably in the water is what had happened with the previous Supreme Court case in Michigan versus EPA, where EPA was ultimately struck down by not considering costs enough. But the then administrator came out and made a very public statement that said, well, it effectively doesn't matter that we lost because just because this was pending, we were able to get the industry to move in the direction we wanted anyway. And so this whole idea of the non-answer becoming the answer, that was certainly something that many of the parties, including us, pointed out to the court. And so I think this idea of what the importance of giving an answer, even in a context where you're going to have the particular rules in flux for years at a time, I think it's significant that the court decided that it was important to take on this case. We can see that as well with the Sackett case, the Waters of the United States case that was argued last month. That was another circumstance where we had changed administrations who were changing the rules as we speak, and even so, the court took up some of the critical legal issues there. So when it comes to future agency actions, I think that's a really strong sign, even in the short portion of the opinion, that the Supreme Court is willing to get involved and to give answers on some of these legal questions. So with my last few minutes, I'd like to talk a little bit about the major questions piece, and I think that's probably where we'll focus a lot of our time. Very briefly, what the court held here is that even though often it's enough for an agency to act based on implicit grants of authority through even ambiguous statutory language, in certain extraordinary contexts that involve significant national issues, issues of economic and great political significance, even a plausible textual interpretation isn't good enough. The court should expect that Congress is going to give a clear statement. So in this case, if EPA was claiming authority to dictate what sources could generate energy across our electricity grids and how much and how fast our country could afford to transition from certain forms of energy to others, that is something that has massive national economic consequences. It's just not common sense to expect that Congress would delegate that sort of power through language like best system of emission reduction, something that vague. The idea would be Congress would have told EPA to do that directly. And certainly there's a lot to be said about what remains unanswered through the case, and I know some of that was discussed yesterday in another context. There's a lot that remains to be worked out, what exactly makes something major and how that's going to be worked out going forward. But I'd like to focus on a couple of points that I think are significant from the opinion that may give some guidance to how the court's going to look at other agency actions from EPA and from other agencies who are taking up this whole of government mandate. First, I think it's critical that the majority looked at the scope of the authority the agency asserted and not the particular application in the rule before it. And I think the example the court gives is a good way to explain what that means. It talked about a prior case where there had been asserted authority to regulate tobacco. And in that case, there was only a regulation of tobacco, but the court said actually the logic of the agency's reading of the statute said that it could ban tobacco outright. And so because the logic went that far, that's part of the reason the court found that question, that assertion of authority was major. It was the same thing here. Even if and the court didn't ultimately decide on this, but even if it had said, we think the particular framework of the Clean Power Plan or whatever comes next might itself not go too far, whatever that means, the logic of the agency's authority that best system could mean cutting down fossil fuel generated electricity all the way to zero, that itself was a major assertion of power. So I think that's important to look at going forward, that it's a signal that the court's not necessarily going to be interested only in the particular rule. So if you have an agency who's trying to get around this opinion by saying, we're, first of all, not going to describe ourselves as, in the press by engaging in transformative actions, and maybe we're going to try to move more incrementally, that maybe the court will still be skeptical of that because it's going to be interested in how far the logic of the statutory interpretation goes. I think the second piece is that the court was really focused on the separation of powers principles and practical understandings of congressional intent here. The majority was really interested, and we see this in the concurrence as well, in this idea of how do we expect the branches of government to work, really keeping them in their lanes, and then trying to understand where do agencies fit here. So this separation of powers approach was really important. And then it comes down to this idea of there's certain things, they didn't go so far as to say certain things that Congress can't delegate to an agency, but certainly because we expect that Congress and the branches are going to stay in their own lanes, it's reasonable and common sense to assume that if Congress wants to do something major in terms of delegation, that it would speak clearly when it does so. So I think that broader institution sense is definitely animating the court as well. The third point is the Roberts majority was really focused on what he called the particular and recurring problem of agencies going outside of their lane. And this, I think, is interesting because there's a lot of discussion, and I'm sympathetic to it, that, is everything a major question now? We're seeing it in all sorts of litigation going forward. And at some point, courts might say, well, if everything's a major question, nothing is. But I also think it's important to look at this because there's skepticism that agencies are looking at the situation we have now, the current political climate, and the majority of the court seemed very skeptical of agencies who were assuming authority Congress didn't delegate in the court's view that has really expansive consequences. And if this is a trend, if the court thinks that this is what the courts are doing, what the agencies are doing over and over again, then maybe not, but maybe the court wouldn't be so surprised if a number of cases coming up do in fact turn out to be major questions if this is what agencies are doing as part of a growing trend. And then the last thing I'll note, because I'm here as a state government lawyer, is I thought it was interesting what the court didn't say about the role of state authority, at least in the majority opinion. When we had briefed this issue as a state coalition, we certainly led with major questions, but we also talked about a federalism canon, which the court had some cases that talked about when agency rules invade an area of traditional state authority, that's also an area we expect Congress to speak clearly. And the majority didn't reject it, but you don't really see that discussion until you get to the Gorsuch and Thomas concurrence, where that idea is actually one of the listed factors. So that's something that as a state attorney I am looking at with particular interest, especially as we see courts trying to parse this. So I think how much that role is going to play going forward is something to be watching. I think it's really consistent with this idea of this institutional view of, everybody within the federal government stayed in their lanes, but also from a horizontal federalism perspective as well. I think that's going to be significant to see how courts weigh some of these agency rules coming forward. So for us, ultimately, as a state, this was never a question of the substance of climate change or energy policy, but it was really an institutional question of who gets to decide these major questions with broad implications. So we were really gratified to see that the court said, look, when you have something that is this significant, the who decides needs to be Congress and the states. So we're encouraged, of course, by the decision and grateful for all the work that went into it. And I'm hoping that some of these broader institutional principles will continue to develop that doctrine going forward as we hammer out the details, which we'll talk about more.
Well, thank you, Lindsay. Derek?
Well, Lindsay did an excellent job covering major questions, doctrine and the legal framework, and some of the questions at issue in the West Virginia case. So I want to take a minute just to talk about two a little bit more policy-oriented or philosophical points, and then talk about what I see next. So 2 points. A, the rule of experts is bad, and B, agencies must be cabined. And I'll have 3 points under each of those. So first, the rule of experts is bad. The major impetus behind giving agencies leeway is the idea that in our complex world, Congress cannot be expected to legislate on everything. And in any event, agencies have experts who can make better decisions. There are 3 major problems with this idea. First, experts lack accountability. Justice Gorsuch, citing Federalist 11, wrote in his concurrence, quote, "The framers believed that a republic, a thing of the people, would be more likely to enact just laws than a regime administered by a ruling class of largely unaccountable ministers," close quote. He juxtaposed this to the vision of Woodrow Wilson, writing, quote, "Woodrow Wilson famously argued that popular sovereignty embarrassed the nation because it made it harder to achieve executive expertness. In Wilson's eyes, the mass of the people were selfish, ignorant, timid, stubborn, or foolish, close quote. He went on to describe Wilson's less than uplifting views of minorities and immigrants. Some continue to parrot Wilson's ode to the experts. During the height of the cap and trade debate, listen to what Thomas Friedman wrote in the New York Times. This was in 2009 when Congress was debating what would ultimately become the Clean Power Plan. Friedman wrote, "One-party autocracy certainly has its drawbacks, but when it is led by a reasonably enlightened group of people, as China is today, it can also have great advantages. That one party can just impose the politically difficult but critically important policies needed to move a society forward in the 21st century. It is not an accident that China is committed to overtaking us in electric cars, solar power, energy efficiency, batteries, nuclear power, and wind power." Well, put me in William F. Buckley's camp. He quipped that he'd rather be governed by the first 2,000 names in the Boston phone book than by the Harvard faculty. And students, if you need to know what a phone book is, you can find me after this panel. I suppose I'm willing to substitute the 535 members of Congress for the first 2,000 people in the phone book. There's not been found in the history of the world a better system. Members face elections, and their agendas will face a referendum even if they themselves are in a very safe district or state. They are accountable to the people, 435 of them every 2 years, 100 of them every 6 years. Let's remember, too, that legislation also must have the acquiescence of the president or a supermajority. That is true accountability, as responsibility for policy decisions is clear and policymakers can be held accountable. Second, the American people have less confidence in experts and agencies than ever before. There is a huge vulnerability in the Wilsonian logic in our day. Experts and trust in institutions has never been lower. The American people look at what experts told us about COVID or the constant doomsday predictions of climate scientists, and they have what I would say is a healthy skepticism. Or perhaps more importantly, maybe people perceive that experts in one field should be listened to as one voice among many. Dr. Fauci knows a lot about infectious diseases, but he apparently knows very little about education, business, religion, or a dozen other topics. That we deferred to his expertise to balance all these complicated factors at play ended up leading to historic learning loss, depression, and economic catastrophe. Climate scientists may know a lot about the climate, but they're hardly experts in economics or human flourishing, or at least they're not necessarily so. They know about their climate models and they're worried, and I understand that. They, even at EPA, cannot be entrusted to balance all the other factors at play. That should be left to our representatives. These representatives are a group of diverse thinkers from every part of the country, geographically, socially, racially, politically. They have the power to solicit testimony, expert advice, debate issues, and formulate policy in a way that lasts beyond a single presidential administration and can provide more certainty to business and capital. Third, to the extent you need expertise, Congress has plenty. Kagan's dissent spends some time on the idea that Congress does not have expertise. She writes, quote, "Of course, members can and do provide overall direction, but then they rely, as all of us rely in our daily lives, on people with greater expertise and experience. Those people are found in agencies," close quote. She continues, "Why wouldn't Congress instruct EPA to select the best system of emissions reduction rather than try to choose that system itself? Congress knows that systems of emission reduction lie not in its own, but in EPA's unique experience," close quote. She goes on to say, "Nor can Congress realistically keep track of and respond to fast-flowing developments as they occur." All of that, quite simply, is hogwash. Congress has been debating climate change since the late 1990s when it rejected the Kyoto Protocol unanimously. There have been at least 3 extraordinarily major pushes for climate legislation since that time. In that sense, it was ahead of agency action. On the expertise point, though, it's likewise nonsense. Congress has committees of expertise and dozens of staffers with deep experience. They can, and they do, call upon experts all the time. The real problem for the left is perhaps that they disagree with Congress's conclusion to depend more on research spending and some fairly modest, but still bad in my opinion, spending and subsidies to subsidize alternative energy. Congress considered a cap-and-trade system of emissions reductions and they've considered a carbon tax system of reductions, and they have rejected both. Americans, perhaps it's because Americans will tell pollsters that they are concerned about climate, but they also do not feel that they can pay more to solve it. 40% of people say they would pay zero more, and the median answer for how much more they would pay is $40 a year, substantially lower than we're already paying as a government today. Also, perhaps they're skeptical that our actions may not do much here in the United States for a global phenomenon. And here's a hint, they'd be right about that. Without China, India, and the rest of the globe participating, our actions here are pretty fruitless. Well, within a year of the House passage of the cap-and-trade bill, which the Senate did not pass, Joe Manchin ran for Senate and aired a campaign commercial showing him shooting a copy of the cap-and-trade bill as a Democrat. That flurry of legislative activity, along with some overspending, started the Tea Party movement. The people really did have a voice. B, agencies must have a check on their discretion and their power. First, human nature has not changed. Of course, the framers were not right about everything, particularly slavery and the rights of non-landowners and women. But they got many big things right, and their insights into human nature and the insight of having ambition check ambition were spot on. Federalist 51 puts it this way: if men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. That's as true today as it was when it was written. We must have controls on government. Those controls come from branches checking branches and states checking the federal government. Second, agencies are not angels. At its root, that's what the debate over the major questions doctrine is all about. There must be some kind of check on agency power. West Virginia versus EPA notes that the label major questions doctrine refers, quote, to an identifiable body of law that is developed over a series of significant cases, all addressing a particular and recurring problem. Agencies asserting highly consequential power beyond that Congress could reasonably be understood to have granted. Even Justice Kagan admits as much when she acknowledged in her dissent that agencies should not operate outside their traditional lane or put forward regulations that conflict with or wreak havoc on Congress's broader design, the so-called misfit problem. Something is clearly wrong when OSHA mandates vaccines, the Attorney General bans drugs, the CDC stops evictions, or when government uses a program to provide loan assistance for military personnel to spend $400 billion toward all student loan borrowers. These are all misfits. We can debate the right contours of a doctrine to check it, but it must be done. Third, our government is limited with enumerated powers. Our Constitution starts from the premise that the federal government can only exercise its enumerated powers, and do that only if it does not violate other constitutional provisions. The default then is against government power and for the liberty of individuals against government action. This same concept should apply when Congress delegates to agencies. It needs to be clear with that delegation, particularly when policy decisions, major ones, are involved. It's perfectly appropriate, as the chief wrote, to, quote, presume that Congress intends to make major policy decisions itself, not leave those to agencies. I'd perhaps go further than just that presumption, as I suspect many here might, but it's a good starting place. So, where to next? I'm watching the DC Circuit in 3 cases challenging the left's effort to end the sale of the internal combustion engine. President Biden has put forward an executive order to call for 50% of all automobile sales to be electric by 2030, and California wants to eliminate the sale of the internal combustion engine by 2035. Biden here wants to see the transportation sector change from fossil fuels to electricity, just like Obama wanted a change from fossil fuels to renewables in the utility sector. They are torturing the Clean Air Act and regulations to get to this predetermined goal. They even did a regulatory 2-step here for the first time. Congress gave DOT the sole authority to set fuel regulations back in the 1970s after the oil Arab embargo. It told DOT that it cannot consider electric vehicles when setting its standards. After Massachusetts versus EPA said that EPA needed to decide on endangerment, it's also been involved. But the last 2 administrations to do this issued joint rulemakings altogether in the spirit of the Massachusetts versus EPA case, which said that they could regulate harmoniously. But with such an audacious goal, they had to change tactics. This time, they had the Californians go first, then EPA, and then DOT. It looks like they're trying to avoid EPCA's limitations, that's DOT's statute, which says that they must consider feasibility and cost along with safety. Interestingly, NHTSA admitted that its rule on fuel economy would lead to 1,800 additional deaths. I guess we shouldn't be too surprised because the person they put in charge of NHTSA actually had no experience whatsoever to do with safety. He was an environmentalist, quickly put out this rule, and then went to go help run CARB in California. It's hard for me to see this as anything other than EPA and the administration gone wild part 2. So, in sum, a little bit tongue-in-cheek, human nature continues, our founders were right, we must check agencies, and long live the internal combustion engine. Thank you.
Thank you, Derek. I guess we're going to Sean. I'm hoping, Sean, that you don't just agree with everything that's been said so far.
I know I am the left. From our perspective, at least. So this is probably the 4th, 5th, 6th time I've spoken to various Federalist Society groups over the years, mostly about sort of environmental regulation stuff. I have always enjoyed it. I went to the University of Chicago at a time when the faculty was just still to some extent, but in the early 90s was just laden with these incredible conservative minds, Posner, Easterbrook, Richard Epstein, and though I don't share a lot of their outlook on things, although I definitely have retained some, I benefited tremendously from the back and forth. I'm a big believer in sort of debate, defending if you believe something, you ought to be able to hear someone who strongly doesn't believe it and re-examine it and come out the better for it. That said, I felt some real hesitancy about coming today, despite being flattered by the invitation. I know a lot of people in sort of certainly the environmental community, but much more broadly on the sort of other side of the political spectrum from most of y'all who I think you would want to hear from who are very unlikely in the near term to accept invitations like that. And I just want to say just a word about it. I think it's, and no big surprises here, but I think it's partly the close association of the institution, the Federalist Society, with a certain kind of really hardball sort of judicial appointment politics, as that was exemplified in part by the Garland and RBG replacement sagas that I think harmed not only the court, but also the way a very large portion of the population sees the court, which of course matters a lot for the court's own efficacy. And so that's one thing that I think is just extremely hard to sort of process and accept. And then the other one is I think the institution did not, I know a lot of individual members did, but the institution did not speak out clearly and loudly when there were very grave threats to the rule of law in the last administration. Which was a particularly significant failure, I think, because of the close overlap politically between the Federalist Society and the Republican Party. So I also want to say I'm not speaking for any client, obviously. I'm not speaking for my law firm. But I'm nonetheless glad to be here. Again, I believe these kinds of discussions are important, grateful for the invitation. I believe that the spirit of liberty is the spirit that's not too sure that it's right, and that applies to me as well as you. So let's. And by the way, that was like a bad learned hand quote. No one should claim that I mean, it was the substance was there, but the wording wasn't quite. So that's the end of the airing of my grievances for now.
Winner of the feats of strength.
Right. But I'm going to go to the airing of grievances of esteemed conservative critics or commentators of the West Virginia decision, of which there are quite a number, as you probably know. And I'm going to just kind of mention them. It's a little bit unfair because I'm going to throw them out. I'll mention some names of people and throw out some criticisms. And not all the criticisms are shared by all the names, but my point is more to sort of let you know what some of the lines of argument are, and be happy to talk about particular views. I'm going to cite Tom Merrill, Jonathan Adler, who I think may have been one of the conceivers of this very panel, and Adrian Vermeule on the Harvard faculty. One criticism is that whatever the sort of Article 3 jurisdiction status of the West Virginia case, the court didn't have to take it, and it very much had the decision to take it, and this court's sort of approach had a very much advisory tone. And I think Lindsay almost kind of said, yes, the court is worried about what would happen next time. Nobody thought the Clean Power Plan was ever going to be enforced. So maybe it wasn't technically mute, but to take a case where really the consequences are in the future was at least controversial. And Merrill says that that aspect of the case led the court's formulation of the major questions doctrine to take the form of an abstract exercise in political science rather than a sort of emphasis on a particular factual record and set of circumstances. So that's one. I could go on about that, but that would be back to my grievances. Another one, probably the central one, is the approach appears to relegate textualism to almost no role or a sense, right? Most of the time when we read a statutory case, the court cites some very familiar quote. We begin and often end with the language of the statute. West Virginia doesn't do that. It starts with a discussion of this line of cases, and the text comes at the end and almost as an afterthought, which may be a problem if most statutory cases still should focus on textual analysis. Another factor, another criticism, sort of echoing a common refrain of Justice Scalia, is that the opinion cites a whole bunch of factors like, the amount of, how novel a agency action is, and cost, and whether there was prior failed legislation. And these are sort of amorphous and fuzzy, and none of them are given any particular weight, and it's sort of a totality of the circumstances test, and that's hard for lower courts to grab onto. And then Vermeule's most comprehensive critique is this decision is a wholesale abandonment of sort of conservative approaches to deciding cases, textualism, originalism, traditionalism, and an emphasis on judicial restraint. So whatever. There's a lot of, and as is the case with almost any big decision, there's praise and critiques. But I think there's been quite a bit of critiques, including from perhaps surprising sources. I'll say a bit about my own view on the major questions doctrine. So I think there is this line of cases, Brown and Williamson, MCI versus AT&T, and a number of others, that applied a sort of similar inference, that if the agency's doing something sort of really unusual, big, different, then there should be a little more support for it than if it were doing something routine. I found a good quote from the French scientist and mathematician Pierre-Simon Laplace that I like. The weight of evidence for an extraordinary claim must be proportioned to its strangeness. There's something very intuitive about that, right? Your kid comes in and says he's seen a dinosaur in the backyard. You say, that's cool, but I need more evidence of that than if he'd said he'd seen the neighbor's dog or something. And I think as a rule of statutory construction, that if the agency's claiming to do something big, something it's never done before, something that would involve it in something that doesn't seem expert in, something that would have onerous consequences for some constituency, it should demand more than if that were not the case. And I think that's pretty benign, common sense. I'm not sure it needs like a name of a doctrine. It's almost like kind of a subpart of statutory construction. I think it should be an adjunct or a component of statutory construction, not a replacement for statutory construction. But I think something like that is kind of benign. I'm not super troubled by that. I think Lindsay and I probably continue to disagree about how that should have applied here. But if that's what it is, and I would also acknowledge about the Clean Power Plan's construction that it was a debatable move. It was an aggressive rule. And I think one reason it was structured that way is because industry, the power companies wanted flexibility in trading. So it was not necessarily bureaucrats trying to step on the neck of the public. It was trying to mirror what industry kind of wants to do and what it does in states that have programs. But I think there was a statutory argument that Lindsay made at various points that was plausible and I think could have justified a decision against EPA using pretty conventional statutory construction. Now I'm going to describe another view of major questions that I think really is not benign, is quite troubling. I do not know yet how this is going to evolve, but I think there's I have some concern along these lines, and that is major questions as a means of achieving sweeping deregulation that Congress hasn't seen fit to enact. There have been various points, including during the Contract for America period, during the George W. Bush administration, and certainly during the Trump administration, where there have been efforts to do sort of systematic, really big rollbacks of regulation, changing the basic principles. There's been all kinds of legislation that's failed. I don't think most people want it. And I think there are certainly regulations that should be gotten rid of and others that should be changed, but I think on balance, things like food safety, environmental quality, and a lot of other things have massive benefits and public support. And I think if the doctrine is about honoring Congress's decisions over that of unelected people, then the doctrine can't allow unelected judges to basically amend statutes through reinterpreting them. And when the doctrine is misapplied, that's what you've got. And I think that is a real risk. Because sometimes Congress wanted agencies to make technical decisions because though Congress does have some institutional capacity, it doesn't have the capacity to go out and evaluate technology for every single dangerous air pollutant all the time, right? And it can properly say, agency, here are the criteria. We want you to protect public health, but you do the lab work and make sure the standards are reflecting contemporary technology, et cetera. So that's a concern. I think I think Lindsay mentioned that there's an awful lot, these claims, because the test is a little open-ended and because lawyers like to try to use recent Supreme Court cases to their maximum effect, it's being cited all the time, including in cases that look nothing like the Clean Power Plan. I would differ from Derek about the motor vehicle cases that he referred to in the DC Circuit. EPA has relied on that provision, Section 202 of the Clean Air Act, many, many times, including for greenhouse gases. Electric vehicles and partial electric vehicles have been around for a long time. The industry has said it wants to go there independently. And so to say that that's a major question seems to me verging on the sort of scenario Lindsay suggested, that if everything becomes a major question, the doctrine doesn't have much meaning. There are some things about the structure of the test that I think are potentially problematic to the extent a rule's controversialness is a factor in making it a major question. It does kind of invite this kind of working the refs or heckler's veto kind of thing that, if you protest a lot, if you get a lot of amicus briefs or whatever, you show that it's really controversial. And that seems to me different from deciding whether the law authorizes something. The law-politics distinction seems really important, and it seems potentially compromised by a particular reading of this rule. So that's what I worry about, it becoming an ad hoc, standardless, deregulatory machine. There are people who think comprehensive deregulation are a good thing. And maybe I would agree in some cases, but I think in most cases it involves statutory process, not judicial reinterpretation. I think sometimes, I think this doctrine invites people to say, is it a major question? Does it trouble me in some way? Do I think this is terrible policy? And that leads judges down somewhere that's very bad, because I think applying the law inherently involves making decisions, enforcing others' decisions, even when you really disagree with them. And I think this doctrine kind of invites, it doesn't, I'm very heartened by the fact that the Chief Justice's opinion repeatedly says this is for exceptional cases. And he clearly saw the CPP, Clean Power Plan, as a really exceptional thing, an enormity of a rule. But I think there's some of the uses of the case go down that line. Let's see if I want to. Certainly, I strongly disagree with litigants who are saying that just because a rule is important or involves a lot of money, it triggers a doctrine. That can't be. We have all kinds of, as you all know, statutes that regulate an industry across our third of a billion nation that necessarily involve large costs and large benefits. That's not what West Virginia says or claims. And now a few miscellaneous things in my role as your gadfly on this panel for just to think about. One, obviously there are people who think that the science is still contested or its implications are uncertain, but I really would suggest that conservatives should be really reluctant to be seen, as is the case now, as the party that is opposing any meaningful national efforts on climate policy. Like, if you have a better idea, given what the science says, bring it forward. But it feels like a lot of the energy is designed to frustrate what the other side thinks are good ideas. And I think that's a perilous place to be going forward. I'll say just a bit, and I'm sure this will be in the back and forth on the whole of government, which is sort of in the description of the panel. I think I readily understand if you're really worried about agency overreach, that sounds terrible. That's like every agency is going to be the EPA, and I don't think that's the way it should be understood. I think what it is saying is climate change is this phenomenon that is affecting all of us in profound ways, and if you're an agency like the General Services Administration, right, runs government property, you need to think about the fact that the weather patterns, the temperature is going to be different, and take account of that in your management, because otherwise the taxpayer is going to suffer. That's an example. Use your existing authority and think about this unwelcome new phenomenon that's happening. And obviously we can fight about particular instances, but that's what it is. It doesn't purport to say there's some new substantive authority there. Okay, I would also say, I think that climate and the sort of clean energy revolution that's happening in this country that Congress just really committed us further to is going to require all of us. I've suggested that conservatives need to really, think again and not be in just the position of trying to stop everything, but certainly true for the left side as well. Like, my understanding of what it's going to take is going to be building a lot of stuff pretty fast, and that is hard for progressives who want there to be a ton of process before any new power line or structure is built, and that is going to require a real painful rethinking. So I don't mean to suggest that that this is that one side is fully enlightened in any way. It's going to require a lot of changing paradigms for everybody. And at that point, I think I'm going to relent. And thank you again for having me.
Well, thank you, Sean. We're going to hear from everybody again. I'm going to give everybody an opportunity to respond to the comments that were made, and then we're going to open up for questions, so be prepared for that. Lindsay?
All right. Well, thanks to Derek and thanks to Sean. I really want to echo the idea of how important I think it is that we have these debates and these discussions. I think it's critically important. And in litigation like this, it was really a pleasure to get to litigate with Sean and so many others. It was really professional and collegial, and the excellent advocacy on all sides, I think, really strengthened all of us in the way we were thinking about it. And I really appreciate your collegiality and professionalism at all stages in this case.
Back at you.
So, I'll touch on a couple of things. First of all, about this idea of the legitimacy of the court's decision and the abstract nature, textualism, and some of this idea about the perhaps more aggressive or more dangerous version of major questions. So on that first piece about the Supreme Court reaching out and taking a decision that it needed to, I think if we're in the zone where we're talking about prudential considerations of whether the court needs to take something, I think there's certainly some fair points there about whether it should have. But I think it's important to emphasize that once we're in that prudential zone, there are important considerations on the other side too. Some of the ones that I mentioned earlier about not having a decision effectively becomes a decision, and I think the Supreme Court was really aware of that. And we are in a context where we see so many of these rulemakings going back and forth, where not having, perhaps a case that comes up in the traditional way, where we have a rule that's still in effect and is going to stay in effect for the next, foreseeable future. If that's not the world we're moving in, then not giving a decision can have real world consequences too. So I think that's important to remember, that there are real world consequences on both sides of this issue. And then when it comes to whether that takes away from the court's ability to effectively decide this, the way that we looked at it, I think it's fair to point out some of the concerns there. But if this really is a question of statutory interpretation, then it doesn't really matter the particular facts of the rule. If what the court's doing is saying, what did Congress put on paper and what did it enact into law and what does that mean, then I think it is fair to look at not only the particular rule, but also where that logic leads. So I think that's an area where we can have strength in the court's decision. And this is one where maybe I'm being a little bit overly optimistic, but I also think it's important for the court to weigh in to give agencies more legitimacy in what they do. It's not just a concern about legitimacy for the courts, although I certainly share those broader institutional concerns. This case was not about whether Congress can delegate questions like the Clean Power Plan or related issues. A couple of justices would have liked to take it there, but at this point there seems to be only a couple who are interested. But it's really about whether Congress in fact delegated that. And I think pushing Congress to speak clearly and make those big decisions can give the American people more confidence that their representatives are the ones making those. And then when the agencies are coming in and filling in the details and implementing the programs, I think that can give an agency like EPA more legitimacy, especially in a time where there is so much division and so much criticism of agencies in Congress and frankly, all of our branches of government and actors there. So when it comes to the textualism critique, certainly in this context, and as someone who argues frequently for textualist positions, that's really important to me, and I hear those concerns as well. The way that we looked at this is textualism is not just the words that are written on the page, but it's also the words that you would fairly expect to be on the page and aren't there too. So I think it's fair to raise those critiques because it is different than what you may do in the run-of-the-mill statutory interpretation case, but that doesn't mean that it's atextual. And this idea of a clear statement requirement, of looking for more than ambiguity, that's not new in the law. We see it in the presumption against extraterritorial application and other doctrines like that. So this isn't new. I think what matters is looking to see where the court's grounding it. And so the court here is grounding it in this idea of how we have set up our system of government and separation of powers, and also the idea of what would we reasonably expect a lawmaker to do. And if lawmakers were actually delegating power of this importance, it's reasonable to expect that they would have said that directly. So I certainly share those concerns that this can be subject to abuse, but I think it's important to look closely at what some of the principles are behind requiring a clear statement in a particular context, and then to see whether courts continue to adhere to that basis. So finally, on this idea of how aggressive major questions can be, I also share some of the concerns which I think are always going to be true when you have an imprecise doctrine. There's never going to be bright lines that say what's major, what's not. But I think it's also interesting for us to question where our default presumption is. Do we set our default in an area that says regulation is appropriate unless we see something that tells the agency to stop? Or should the default be, at least in these extraordinarily broad contexts, that the agency can't act unless we see more? So I think the way you look at that question may depend on where you start that. And again, I do think it's going to be very interesting to see how courts work with this doctrine moving forward. We're seeing it raised in a lot of context, and I do think that there's a lot of room to be done to flesh it out. But I think the principles the court has given us give us a pretty firm foundation to keep working through. These ideas like Derek talked about agency expertise and competence, I think that can be an important area to look at because it goes back to these institutional concerns about what are agencies set up to do and what do they have the capacity for. This idea of whether something is a new interpretation, that can really speak to whether we all understood that's what Congress is doing or is an agency trying to do something dramatically different. And I also agree that I think that the repeated emphasis that this should be extraordinary and limited, I hope that lower courts heed that and are fair in this application going forward. But I also think that those words mean something in the majority's opinion, that the Supreme Court is giving a signal. This is not a world where everything becomes a major question in a way to supplant statutory interpretation. And finally, briefly, I think just this idea again of this sort of accountability matters in terms of making sure that everybody who should have a voice in the process for these decisions does in fact have that voice. I agree with a lot of what Sean said, that many in industry were pushing for some of these cap and trade measures, but what's true across the board or across the country or on average is not always going to be true in particular areas. And as a representative from West Virginia in particular, that wasn't true in our state. That wasn't true in a lot of regions. And so it matters to us that Congress is the one who's able to make these decisions because Congress has voice from everyone who's affected and is able to take that broader view. So I think there is a lot to be seen what's going to happen going forward, but I think we do have a good playbook to see that play out.
Thank you, Lindsay. Derek?
I've just got three things to bring up. First, the point that admin law reforms haven't been passed. I think we shouldn't be too surprised at that because we're asking Congress to take more responsibility and have more accountability. And so they may need some help from the courts on that. What I mean by that is that there's a mismatch, right? It's fairly easy for a congressman or a senator to vote for a fairly vague bill and say, I just voted for clean water. I just voted for clean air. I had no idea that EPA was going to go and do this. And that really breaks accountability with the voters if you allow vague or large grants of authority without very clear signposts. That disrupts that accountability. Second, I agree with your point that the Clean Power Plan was very aggressive and that they tried to make companies more amenable to supporting it. And I think that shows that it was a very political decision. And where should political decisions belong? Who should be weighing all of the trade-offs? Is it EPA, which has an expertise in environmental issues and can tell you the right technology for a particular power plant application? Are they the ones that ought to be making those decisions? Or should it be in the people's house where all the different regions of the country, all the different special interest groups, the public itself has a voice? So I think that actually just demonstrates the point that this wasn't some small administrative thing where EPA was just deciding what the proper level of pollution was. They were trying to implement policy. And then third, on the motor vehicle regulations, it's the most expensive regulation of the Biden administration. It was the most expensive regulation of the Obama administration. It is a huge cost, and I think in this case, unfortunately, there are industries that are captive to regulators, that are scared of stepping up against California or their federal regulators and fighting for their customers. I think that's lamentable, but I think that is kind of what's happening. And so, the fact that the industries are okay with it shouldn't mean that the American people are okay with it necessarily. After all, if everybody's got to play by the same rules, if all the companies have to build a vehicle that will fit within this thing, they can still compete in a limited way. But really, you need garden variety consumers to stand up. And we saw that happen. We're seeing that happen in California. We're seeing that happen with the EPA regulations. It's not as though they've always been doing this. They've been doing sort of this. They've been increasing the efficiency of the internal combustion engine. They have been doing that for decades. And EPA has been doing it since the Mass versus EPA case. There have been incremental improvements in the efficiency. But this is a whole nother thing. This is not increasing the efficiency of the internal combustion engine. This is explicitly designed, they say it's explicitly designed, to fulfill the president's executive order to have 50% of sales be electric vehicles. It is different in kind just as the Clean Power Plan was different in kind. It wasn't a matter of trying to increase the efficiency of existing power plants. It was trying to change the fleet of power plants, just like this is trying to change the fleet of automobiles. So it is a different thing in kind.
All right. Thank you, Derek. Sean?
Do we have any DC Circuit judges out there? It sounds like we're already into it. The case is being briefed now, so and it'll be argued in September 2023. So I guess on the cars, I'll just say, I mean, a couple things. I mean, the fact that the regulated industry hasn't, I mean, maybe they have false consciousness, but that seems like a surprising thing for free market advocates to say this particular industry doesn't know where its future lies or whatever. There's no auto manufacturer who's challenging any of those rules. In fact, they're intervening to support them and have said that they believe that electrification is the path forward for them, for their businesses, for profitability. We've had electrification has obviously been going on, and that includes things like hybrids. In California, zero-emitting vehicles have been in place as an air pollution control tool since the 90s with EPA approval. So I don't think it's so new, but that will be, and these are interesting cases, and I'm sure we'll all follow them as they go along. I want to respond to Lindsay's comment about textualism and missing words. I think we might not disagree. Like, I would agree that it would be consistent with conventional textualist analysis for the court to say, this looks like an averaging or a cap and trade type program, but I don't see the language in there. There's other parts of the Clean Air Act that have it. I think that weighs against EPA's interpretation. And we could argue about whether that's right, but I completely agree that's legit. What I think the critics are saying about this opinion is that it sort of doesn't start with a text. It starts with these vibes. This is really big. People, Obama said it was big, and like all this stuff that is as Merrill said, feels like political science in some and maybe when it's the Supreme Court and things like sticking to the record and all that, and like there's all these amicus briefs, and it's like, just tell us what the rule is. But in the hands of courts throughout the country, there's a lack of structure. There's an inversion of usually courts look at the language and they say, here's what we think it means, and here's like a policy consideration that reinforces this or that isn't strong enough to overcome the language. This one's the other way around. And I think the criticism is sort of the structure of the analysis, not necessarily I am not here claiming that, the court was totally, the court could not have ruled for the petitioners consistent with conventional methods. So the question is, why wouldn't you start with the conventional? We start with the language of the statute. And then if there's some inability to decide the case that way, but I think the court wanted to send this message across the bow, and we can debate whether that is a good thing for the court to do. I wanted to ask a question, maybe it's still too recent, but we had this debate about whether the court should take the case, and we said, they're going to do something new. And you all made these arguments about the need for clarity and certainty. You guys did not use, so for over a year, I think the case was in abeyance in the DC Circuit after Trump got elected, and we had another, not quite as long, but very long oral argument about the Clean Power Plan, and the states that were supporting the Clean Power Plan and the environmental groups wanted the DC Circuit to decide. We thought that argument had gone well. We thought there was a Supreme Court stay in effect, and for that to go away, there had to be a Court of Appeals decision. So we kept telling the DC Circuit, please decide the case, and the government said, wait, we're doing a new rule. And we made these kinds of arguments that you made, Lindsay, about the need for certainty and the need for the thing to be decided. I was always afraid you were going to cite our filings back to us, but you didn't, but you made out okay even without doing that. Let's see. Yeah, I guess I'll just say, I should clarify my comment about the Clean Power Plan being aggressive. I think the statutory construction was, It was debatable. I think it was sound, but there were fair arguments. It wasn't resolved by prior case law or whatever. I don't think, in retrospect, it was an aggressive rule in terms of stringency, and that was one of the remarkable things, is that by the time, for example, the DC Circuit finally did decide, and there was this argument about whether the Supreme Court could become involved, the power sector, without being federally regulated under this provision at all, had reduced its emissions to well below the 2030 targets for the Clean Power Plan, but because of market pressures and gas replacing coal and renewables replacing both. So that was another way in which we thought, why have a case about a rule that's not only never going to be in effect, but that isn't constraining anymore. It wouldn't do anything. So in that respect, I don't think it was aggressive. Okay, and then I guess I'll just say one thing on accountability. I mean, I understand it's true that sometimes politicians or members would have incentives to legislate broadly in favor of some anodyne value like clean water, and then have an agency or someone else or a court do the hard work. That is a problem. I don't think, though, that it justifies sort of a kind of, it indicts the whole body of the Clean Water Act and the Clean Air Act are actually filled with pretty specific, I mean, even this provision has a structure to it. It told EPA what to do to go out and find the best system of emission reduction by looking at the world and looking what's demonstrated. So I don't think that that legislators, have those incentives, which they have since the beginning of time, is a reason to say, well, we're not going to follow laws. I thought this was about legislative supremacy. And of course, it's not as if legislators don't get campaigned against based on things that agencies do, right? They often do. Say you're the party of the big government, and this terrible thing happened, and you're responsible for it, as do presidents. So anyway, I'm not willing to concede that there's sort of categorically an accountability problem with these kinds of delegations.
All right. Well, thank you, Sean. And please give another hand for the panelists on this opening remarks. So I'm sure we could continue responding, but we only have about 20 minutes left, and I want to make sure we get lots of questions. So go ahead and come up to the mics, and I will ask you to ask a question, preferably not one that's like a long statement of your own views with comma, right, question mark at the end of it. But maybe
like you've done this before.
I've been to plenty of these before. So one thing I want to ask the panel, I'm going to use the moderator's privilege to ask the first question, is, I think Lindsay mentioned, and it's mentioned in the concurring opinion, the federalism canon. That's another clear statement rule. It's one that I'm familiar with, having litigated for states. And you came across this canon, and it seemed like a great canon that you could use in a lot of the cases that states were litigating. And my experience was, and correct me if I'm wrong, but it just seemed like it's mentioned in Gregory versus Ashcroft. It's the idea that if the federal government is changing the balance of power between the states and the federal government by regulating an area that's traditionally been reserved to states, then there needs to be a clear statement rule, much kind of like the major questions doctrine. And you can imagine, it almost seems to me like that would apply in more instances than the somewhat more ambiguous major questions doctrine. But my experience was that it just doesn't seem like you'd make these arguments, and very rarely would courts pick up and decide them. So is that what we can expect to happen here? Maybe why is it that courts don't pick that up? And my intuition would be maybe it's because there's something about, it sounds like the nuclear, it sounds like the nuclear option or something like that. And so is that going to be, maybe this will be fairly limited because of that phenomenon. I want to be like that as opposed to everything becoming a major question. So anybody who wants to lead off.
Yeah, no, I think that's a good question. I wonder too, I think I was in law school, this is terrible, but when the Lopez decision came out, and there was this sense that there was this massive sea change in law, and we were going back to before the New Deal and all that. And then Commerce Clause challenges occur, but it was no sea change. And so I think we don't know. I think federalism canon is, remains pretty important. It is, I was going to say this about major questions. my version of it, the benign one, is not inherently anti-regulatory. If you think about a case like Whitman versus American Trucking, the reasoning was, we think EPA is supposed to base these standards on health, and somebody's saying it's health plus cost, and that's like really surprising given all this. And that was a case where similar reasoning was looking or militating toward a broader conception of agency rulemaking. And I think the federalism canon's like that. It's kind of like sometimes it helps one side and sometimes the other. I certainly try to rely on it when California's prerogatives are. And I know here in the Clean Power Plan, the argument was the Clean Power Plan ultimately affects generation and the choice of different sources of power, and that's traditionally a state role, state PUCs and others. And our position was, though, it's regulating air pollution, and the effects on these other things are incidental, and that's always been the case. And as you say, that didn't end up being sort of addressed in any detail in the decision. But.
Right. No, I agree with that. And I think, again, it's speculation, but I think one of the reasons probably we don't see it in the majority decision is because the majority was really focused on this idea of Congress's role as opposed to the agencies, and really focused on the federal separation of powers. But we do see federalism canon in some majority opinions in recent terms, like the Atlantic Coast Pipeline case from a couple terms ago. So I think it's still there. And I think it's an important principle, but I think there were other things going on in this case why the majority wasn't focused on the state-federal government divide as much as the federal balance of powers.
I think we're going to see it a lot. All the incentives are there for presidents. Both parties are more influenced by the more conservative or liberal wings, respectively. And the president has every incentive to put forward audacious claims through whatever means they can find through the administrative state. And when they get struck down, they use that as a political point to go on to the next thing.
I mean, the eviction moratorium case, I think that there were probably multiple grounds on which that one was going to go down, but the idea that landlord-tenant is a state and local area, and it would just be really surprising, and there was nothing in the statute that seemed to bring the CDC there.
We'll go ahead and go to the audience here, so we'll start over, I guess, on this side. I don't know who was there first, but.
Hi, Devin Watkins from the Competitive Enterprise Institute. I should give a bit of warning. I am an attorney representing the clients before the DC Circuit in the auto emissions case. So I obviously don't expect you to necessarily believe what I think the statute says. So let me quote EPA when it created the averaging program. It said, Congress did not specifically contemplate an averaging program when it enacted the Clean Air Act. And when it enacted trading of credits between various manufacturers, it said, just as the statute does not explicitly address EPA's authority to allow averaging, it does not address the agency's authority to permit banking and trading. So given that, I just don't understand why you think this is a clear case that the EPA has this authority.
So I have both of those are quoted in Jeff Wall's excellent brief. And since we're in the process of briefing it, I think I'm not going to favor you with an answer to that question, but we obviously believe, as the industry does, that EPA's use of averaging and trading is lawful here, as it has been in decades past. Thank you.
Can I quickly jump in there, just because I think this gets to the point. Same thing happened in the Clean Power Plan. I was there. I was in the Senate when President Obama was pushing for cap and trade. And the argument there was, you better do this because you're really not going to like what EPA did, because we don't have the authority to help you on the backside. And then they tried to help them on the backside anyway. Same thing is happening with the auto industry. They sued and then withdrew their lawsuit when the new administration came in, based on promises that they were going to get a lot of subsidies. Lo and behold, you have the Inflation Reduction Act. So I don't think we can be too surprised when industry doesn't confront the regulator upon the promises of a lot of goodies coming down the pike.
All right, we're going to go to you, sir.
David Tryon. I'm with the Buckeye Institute currently, previously with the West Virginia Solicitor General's Office. And we also the Buckeye Institute has filed an amicus brief in the EPA tailpipe case. But anyways, my question is about the Gorsuch concurrence, which expounds upon what constitutes a major question. And my concern about it is, number one, that it's a concurrence. And so I'm interested if you have any thoughts on why, though his details didn't make it into the majority opinion, and you may be speculating, but I'll be interested in your speculation. And second of all, will that have an impact in the future going that it's in the concurrence? Will people say, well, that was just a concurrence? Will the judges say that was a concurrence, so I'm not going to pay any attention to that? So your thoughts, please.
You want to go first?
Sure.
I'd be interested. I want to know the answer.
Fair enough. I mean, I think it is, of course, speculation why it did or didn't make it in. I think the specifics there, one of the things that we were really interested in, it's no secret in briefing this, is all of the justices had really different views of these issues. And what is a major question and when it applies is a difficult issue. So we were really interested to see if a majority of the court would, even if we were reasonably confident that we would have the right outcome at the end from our perspective, but we weren't sure that there would be a majority who would agree on the same reasoning. So I think that may have been part of what was going on, is an interest in trying to get 6 justices who could agree on the principles here. And then when it came to the more specifics, there may not have been that consensus view. In terms of how it's used going forward, I would expect to see courts looking to it because it does give some more clear, check marks. And first, what's major, and then what the concurrence does, it's also a little bit different. It's not just the what's major, but also what are the check marks to say whether you have a sufficiently clear statement. So that could be something else that other justices weren't willing to go that far. But I do think we're going to see courts using it, but it gives a lot of leeway because, as you said, it's just a concurrence, so there's no need for courts to go through that checklist process. But what do you all think?
Yeah, that all seems right to me. I mean, yeah, sometimes separate opinions that have a structure, Jackson, Youngstown, sheet and tube thing, for lower courts, it provides like and as I've mentioned, a common criticism of the majority opinion is that it's a little mushy, a little hard to tell what's a necessary requirement. I do think there's an interesting difference that Lindsay adverted to in terms of whether the sort of ancillary or less than clear, explicit nature of the statutory hook that the agency is relying on is part of whether there's a major question, or is it just go to that after you've decided there's a major question based on effects in the world to decide whether the action is authorized. And I think this is one of many things that will be worked out, over time.
Thank you.
All right, thank you. To you, sir?
Yep, Clyde Taylor from Chicago. As I've watched kind of the administrative state kind of drama unfold, I guess my observation would be that to the extent you think the administrative state is out of control and unaccountable, that you should blame Congress, not the administrative state, because Congress passes laws and they decide in each law how much oversight they want, how much accountability they want. If they don't like what the agency does, they can kill it. They can pass a new law. So I guess I'm sympathy that I believe there's out of control regulators, but I blame Congress primarily for deciding at some level not to hold them accountable and not to pass clear laws. I just appreciate your feedback on that perspective. So.
I think that may have been a comma right question mark question. Does anybody have any?
Do you agree is the question.
Yeah, I think there's a degree of truth to that Congress is to blame in part on that as well. They don't seem very eager to repair that at the moment. That was kind of what I was alluding to with kind of a little bit of a nudge from the court, if you will, to get them to, if agencies can't use decades-old laws that were never used in a particular way and they try to use it a new way and the court strikes it down, it'll be more pressure on Congress to actually get their act together and go back to legislating like they should. So, maybe there's hope in that. First, there's got to be pain, and then there can be hope down the road.
Yeah, I largely agree. I think we may have different views on what things are abuses or whatever. I note there is the Congressional Review Act, which is this like streamlined way for Congress to respond to particular rules that it disagrees with that gets past the filibuster that has been used. But both sides, there was a prominent use of it to override a Trump administration weakening or repeal of a rule about methane emissions from oil and gas facilities that Congress overrode through the Congressional Review Act. So there is that tool that itself kind of reflects an understanding by Congress that it has difficulty sometimes because of internal processes being that responsive.
All right.
Hi, everyone. I'm Kristen. I'm a law student from Connecticut. The SEC claims that GHG emission disclosures are necessary to protect investors in their financial decisions. Do you believe that the SEC has authority under this reasoning to mandate GHG emission disclosures for registrants under their proposed guidelines?
I can start on that one. So this is one where I think they're virtually certain to be litigation in the future audit. So, but what I can talk about is some of the comments that West Virginia and others filed on that proposed rule. You know, we did say that a lot of the same indicia of major question are present there. I think one of the things that's really similar is this idea of, you know, the SEC, who has, you know, a clear and defined role when it comes to investor confidence, and becoming, you know, adjunct climate regulators seems very different from what that role is. So I think that's something that's similar to this idea of, you know, EPA, who obviously has a clear and defined role, but becoming managers of electricity generation. So I think the same sort of things that concern the court in this context here, I think are very likely to concern the court there too. And we're definitely going to see that worked out in litigation when that rule's finalized.
Agreed.
Yeah, and disagreed here.
Right.
Yeah, I mean, so what the SEC is doing, it's not regulating climate. The idea is you're regulating financial risk, protecting investors. Like, that's the theory, and that is, you know, in my view, the fact that they're responding to calls from like massive amounts of the industry, because people like reinsurers are looking out at the effects of climate change on their bottom line and their investors and saying, we need some guidance. This is a risk factor. It is a financial risk factor, and we can't ignore it because it's climate that EPA regulates on the emission side. We can't pretend that it's not there because we have statutes that require us to think about impacts on investors. So that's what it is. There will be a fight about that one for sure, and there will be efforts to characterize it Lindsay's way and my way, and we'll see how that plays out.
And from a policy
Good question.
From a policy standpoint, materiality can take care of all of that. So if it's material, then it should be disclosed. If it's not, it shouldn't. And I'd say that the much larger threat to many companies is a government response to climate change than to climate change.
Thank you.
Thank you. Yes, sir.
Jonathan Wood with the Property Environment Research Center. And my question is about how two aspects of the decision may affect Congress's incentives to legislate. So first, 111D is relatively detailed. The court had text and agency practice and say this is a significant departure. Could the same method be applied to a more typical provision authorizing regulations necessary and advisable, some really broad purpose? And the second part is the court's consideration of failed legislation. Is that going to give Congress pause before taking up bills that might otherwise be dealt with through the administrative state? Thank you.
You want me to?
That's right.
So good question. I'll try to answer maybe the first part and let somebody else try the second part. But on sort of specificity, you're right that there are a lot of statutes that use these sort of general standards. And, you know, how does a court say if you know, the Congress had said set rates at levels that you think are reasonable, you know, and that maybe that's a non-delegation problem, maybe that's what you're getting at, but for major questions purposes, you know, I think it would depend on what the agency did, and maybe a case to cite here is the Michigan versus EPA decision about a regulation or a statutory provision that said appropriate and necessary. Regulate mercury from power plants, EPA, if you find that it's appropriate and necessary. And EPA has said, we think that language doesn't allow us to consider cost. It's just a health-based standard. And the majority of the court said, no, those are broad terms, and any kind of any darn fool knows that cost is a factor that you ought to consider if you're given this kind of open-ended standard. So I would expect to see, and you know, that was under the I think you'd say it was under the old Chevron step 2. Was this reasonable to read the statute in that restrictive way? I expect some cases would be resolved in that kind of way. It would depend on what the agency did, right? If the agency did something that people are saying is a major question, then you could see the court's analysis being problematic for the agency if all it's got was a wide open, an open-ended standard.
I'd say just real quickly on the congressional point is a good question to think about. I don't think that it's going to, just because if it truly is a major question, Congress is probably going to at least discuss or debate it. Somebody will introduce a bill. It will be talked about. And if it hadn't, I'm not sure that would be decisive in a court deciding whether to step in or not, if it's a huge policy impact. Because I think the court kind of said it could be a major economic impact or some other major impact, or it could be a major political impact. Well, if it hadn't been debated in Congress, I guess you'd take the political part away, but you'd still have the other part. So I don't think it's going to have a big impact on whether Congress debates bills.
I think that's fair. And in the majority opinion, when it talks about failed legislation, it really characterizes to say this was keystone climate change, proposed bills that went down. So this just wasn't, ordinary, we're talking about in Congress, certain policy solutions, some pass, some don't. But this was a really important one that went down, and the agency was saying, we're going to do what Congress can't do. So I think that distinction will make a difference going forward. And on the first point, I think that'll also be interesting to see if courts want to move forward with this idea of, can Congress delegate? Because the necessary and appropriate is really getting into this, intelligible principle idea, non-delegation, which was only part of the litigation in the West Virginia case in terms of a constitutional avoidance argument. It wasn't raised head on. So again, we don't see a majority of the court at this point seems poised to go down that road, but I think that's another area to watch in future years to see if that changes.
All right, well, unfortunately, we are at 12:31, and there is and I apologize because you saw folks in line, but there is a wonderful debate coming on.
Certainly welcome to come up, and I don't know if you guys are running immediately.
Yeah, happy to.
Yeah, yes, please come up and talk to the panelists afterwards, but please join me in giving them a round of applause.